hold on. So from 2004 to 2019, what I think you're saying is you did not think that your campaign account was a separate and distinct amount of money.
I don't understand. I don't really understand the question.
Well, you've just kind of said you didn't understand the difference between personal expenses and campaign expenses, and you figured it was just money so that you could use it. Where do you get that understanding from?
I don't know where I developed that understanding that personal expenditures. Just I don't know where that understanding developed. It was just my understanding, and I don't know if it was conversations with members of the board. I don't know if it's something I read along the way. I don't have I can't point to something to say this was the moment that I
So you're saying you're now aware of Ohio Revised Code section 3517.130, and do you know the provisions of that section?
I don't know the exact code that you just rattled off. What I can tell you is once the moment the Board of Elections alerted me in 2019 I was reporting inaccurately, I became aware commingling was not acceptable. And that's when we went through the process of working with them to get these things corrected. And the numbers, the facts bear out. I actually put more in than was removed.
So at the time, then you weren't aware that the provisions of 13.0, which is 3517.130, that says no beneficiary shall. Let me see the specific language here, just because I don't want to say something improper. 3517.13.0 says no beneficiary of a campaign fund or other person shall convert for personal use. That's the first statement included in that. You were not aware of that provision.
What I'm saying is I did not believe I was converting anything for personal use because any money that went in came out. Anytime anybody donated money to me for campaign uses, that's what it was used for. And as I been able to demonstrate, nobody's campaign contributions were inappropriately used or used for anything other than campaign activity.
Well, but as I look at which is interesting you say that, only because I look at the
somebody mute the music in the background.
Yeah, somebody needs to mute there. And I'm not sure where it. Oh well. You initially deposited about $49,000 is what this reflects in 2015. You made expenditures, etc. But there were periods of time when there was more money being used out of your campaign account than amounts that you had contributed to that account, correct?
I think if you go, I think if you go back and look at the timeline, that is what it ended up being.
So wouldn't that be an indication that, Joe Jones' contribution from down the road was being used for personal reasons?
I could see how that could be characterized that way.
Is there any other way of characterizing it?
Well, I mean, again, I believed that the activity was activity where it was non-campaign related, so that's why I didn't report it as such.
And if I understood Mr. Rupert's initial presentation on your behalf, and if I think I hear you saying it, based on your comments from what you presumably perceived from the campaign finance manual by the Secretary of State and other aspects, that you were aware of. It looks like 3517.08A is what I'm looking at right now, and it says the personal expenses of a candidate paid for by the candidate from the candidate's personal funds shall not be considered as a contribution or expenditure. That's what you're relying on as an understanding that personal funds could be used however you wanted to use them, and they're not reportable.
Mr. Executive Director, let me make clear. I did not intend to give the impression that Mayor Elkins specifically referred to Section 3517 08 or 3517 13-0. As you said, that's very hard to know which provisions which. What I'm saying is that reference to, particularly a layman's reference to such code provisions could cause confusion, including, as I cited, those 2 pages from the Ohio Secretary of State's. I didn't make I don't want to make the representation that Mr. Elkins reviewed the statutes, then made a incorrect decision.
And I don't think you did. I am merely asking the question if that is where Mr. Elkins may have gotten his understanding of the circumstances of the personal expenses of a candidate paid for by a candidate should not be considered a contribution. Is that where you got that from?
I don't recall where I developed that understanding.
Is that an understanding you had from the entire time from 2004 until 2019 when it was brought to your attention by the board, or did it develop somewhere in there?
I don't know, sir.
But somewhere along the line, you got an idea that it wasn't a big deal to have money put into a separate and distinct campaign account, but use it for your personal reasons.
I think those are your words. I don't know. I now recognize that this was a serious infraction. Don't know.
Well, I agree.
I believe it was likely, at the point where I did not draw the opponent in 2015, that I started the process and because it was never asked of me, I can't speculate, to be honest with you, sir.
Okay. And I think, well, no, never mind. What inspired, or what was it that led to the various, as I looking at Exhibit A, where again, looks like around almost $50,000 was put into the account in the pre-general period of 2015, and then subsequent payments were made at various times throughout there. What inspired you to make those various payments into the account at any particular time?
As I've noted, initially, the impetus was we were anticipating, and I was anticipating an opponent, and then it just developed into a habit of using this account. In many ways, is a commingled account, as I've admitted and said.
So there was a commingled account, essentially, where you mixed personal funds and campaign funds in your own idea.
I've admitted to that, sir. Yes.
So there was no real impetus as it relates to the timing of when you made the various contributions into that committee as you made them.
If I understand the question correctly, I think the answer to that is correct. As I spent money, I put money back in, and vice versa.
How did you differentiate between, let's just say general expenses? I mean, my family makes payments to our mortgage, make Visa payments, etc. How did you differentiate between using what presumably was your own personal account and these funds? Was there a mentality there that you used?
I mean, that gets into my personal relationship, my personal finances with my wife. But we have an account where a joint account where a portion of my income comes out of my paycheck and will go into that joint account, at which point she'll pay some of our expenses, and then some of our other expenses. As you can see, I was using this commingling this account and using it in that capacity, in that way. I recognize now that that's inappropriate, and if I had known then, I wouldn't have done it that way. So bad on me for sure. I get it.
Let's see. So when you made those payments, you did not consider them a loan, but you really haven't identified what you can, and you didn't appear to consider them contributions. They were just, what did you consider them to be?
Activity in the bank account.
Activity in the bank account, but they're neither contributions nor loans.
Correct, because they were used for personal activity. I did not consider them campaign related.
Okay. You realize, though, that a loan, if whether it's you accepting a loan personally or to your campaign committee, that if a loan is made, there is an expectation that it is paid back. Do you have that understanding?
I do understand that now.
Did you understand it then?
No, because I didn't view it as being a loan.
But you didn't view it to be a contribution. But why did you put the money then in your campaign account?
As I mentioned, originally it was going to be used for the campaign activity, but we didn't end up using it for that. So we didn't characterize it in any way because it wasn't used for campaign activity.
Are you familiar with the fact that Ohio law and actually advisory opinions of this campaign committee, or the campaign committee, the Ohio Elections Commission, prohibit the refund or payment back of monies to either contributors or anyone else involved with the campaign, unless there are specific provisions that allow for refunds?
I'm not familiar with that law, or I don't know the exact statute or reference you're referring to.
Okay. Okay. Thank you. Mr. Chair, I think that's all I have for right now.
Thank you, Mr. Richter. All right, let's go ahead and wrap up Mr. Elkins' testimony. Is there anyone else that has any questions of Mr. Elkins?
I have a brief question. Sorry.
Sure. Yes, please
Mr.
go
Elkins, ahead. Mr. Elkins, was the first merit account, that was your campaign account?
So what happened, I was with First Merit, and then Huntington bought First Merit.
Okay. And that was your only campaign account? There wasn't any other account?
No.
Okay. And then you also, I think your testimony is you had other joint accounts with your wife, or you may have other accounts, but your campaign account was limited to that. Okay. Then I think I have a question maybe for either legal counsel associated with the State's Exhibit A, particularly with regard to the $47,375 that was indicated as payment by Elkins to the Elkins Committee. Can either of you tell us when that was paid and how you determined that? And I will just say, from my own perspective, I had looked at all the bank accounts. I mean, we were provided all of that, and I'm having a hard time kind of understanding timing. I mean, there was some suggestions of when things are paid and what things are supposed to look like, but I'm having a hard time reconciling what I see as deposits, that number, and when that happened.
I can't tell you the exact dates. And I don't believe from my recollection that the $47,375 was made in any one single deposit. I can tell you, and as you can understand, and the evidence we previously provided the prosecutor of taking the personal loans and then later deposits. Some of those monies were used by Mr. Elkins. They didn't always line up, all that sort of thing. So unfortunately, it is very difficult. And I would have loved to have been able to do it, but I don't think I can be able to say this amount of money was borrowed from this credit card on this day and was deposited on this day. So unfortunately, I don't have any direct evidence that can come to that result.
Okay.
But there is substantial evidence that Mr. Elkins did take personal loans, and that a substantial portion of this that we could prove, some of it wasn't available for this $134,000 amount.
Okay, that's sort of what I'm understanding from the statements, and I certainly welcome if Mr. Sims has any response to that. But it appears to me that what is occurring, we can't, as a commission, assume that there's a direct or linear relationship with payments by the Elkins Committee and the timeframes that are being shown in the original column. At least I can't seem to make sense of that based on the statements. And I understand, I appreciate the fact that you could come to some stipulation on what you could agree to. I'm not being critical, I'm just trying to understand in our time frame and the facts presented to us how that lines up. Mr. Sims.
Yeah, yes, Madam Commissioner. I'm going to turn this question over to Mr. Lawler. He is looking at is it the pre-general 2015? Yes. And I believe we can.
Mr. Sims, excuse me, just a second. Just to make sure, are we done with Mr. Richter? Excuse me, yeah, are we done with Mr. Richter?
You're welcome to be done with me.
Yeah, I know. Are we done with Mr. Elkins?
We are done with Mr. Richter.
Anybody else have any questions of Mr. Elkins before we move on to this area?
Only to the extent that he might shed light on this, but I don't have any specific questions.
We can follow back up with that, Ms. Cunningham.
Yes. Thank you.
All right. All right. Let's move on. Thank you very much. Go ahead, Mr. Sims.
Thank you. Mr. Richter, do you want to swear in Mr. Lawler if he's going to provide some testimony before the commission?
Mr. Lawler, do you swear and affirm that the statement you're about to give will be the truth and nothing but the truth, so help you God?
Mr. Lawler, can you adjust your camera to your whole face?
Is that better?
Much better, thank you.
See, I'm just seeing an icon, so I'll take it that Brent is there. Not that I need to see it. I want to make sure all you do. But Mr. Lawler, do you swear and affirm that the statement you're about to give
I do
is
swear and
the
affirm.
truth and nothing but the truth? So help you God. Thank you very much. Okay, Mr. Lawler and or Mr. Sims, go ahead.
So the question was asked about the $47,000 payments. If you look at the pre-general of November 3rd, there's a Form 31A2. There's a series of payments by Elkins. The majority of them are small amounts, but you have one on 8/26 of 15 for $26,500. You have one on 9/23.
We're getting a lot of reverb from you.
Yeah, I have a feeling you've got some other folks in and around you, Brent, that are may have their microphones open or something, and so we're getting some feedback back and forth potentially.
And he's muted now too.
And now you're
Mr.
muted,
Lawler.
Brent. So if you've been saying anything, we can't hear you.
You're still muted. There you go.
Okay.
Can you turn
So
out the
feedback?
microphone?
Yeah.
That's worse. That's much better.
There we go.
Is that better?
There
Yes.
you go.
Go
Yeah.
ahead.
You hear me?
Yes.
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 Yes, thank you.
Okay, I'm muted down here then, aren't I? Am I?
You're good.
And
We can hear you fine.
Okay, you hear me now?
Fine. Yeah. Let's give it a
Okay.
shot.
So we'll start again. So if you have the pre-November 3rd, 2015 general report, there's a Form 31A2, which is the, what we call other income. So it's not considered as a contribution because this is money that at the time when we did the audit, Mr. Elkins said it was repayment of the money that was borrowed. So the majority of them, I believe some of them, like the $50 ones, are direct deposits coming out of his payroll check right into the campaign finance to pay back stuff. But you do have some substantial deposits. 826, you have one for 26,500. You have one on 923, 2015 for 9,450. And you have one on 1014, an ATM deposit of 15,970. So that's the majority of where the big money came from that you're
Okay.
referencing off of the our exhibit. Does it answer your question?
It does. Thank you.
And could I
You're
say
welcome.
in partial response to my statement earlier, follow-up? So for example, I'll give you an example. I'm looking at, and I'm sorry the commission doesn't have it, we didn't know it would be this relevant. I'm looking at, and the prosecutor has this, a Visa signature loan to Mr. Elkins on 8/8/217. For example, the loan itself was taken in 2015 on 8/15 for $14,500. Where there's also additional loans that are like that. Those are some, just to give an example, some of the information that came in. So that could certainly account for some of the large deposits that came in.
Could you repeat that, please?
So this is a loan that Mr. Elkins took, a personal loan, on 8/15, which would be within that filing period, I believe, the pre-general, for $14,500. And all I'm stating that for is
There are
other than
There are no loans.
you're not listening.
There are no loans.
This is
in
a loan from
pre-general
Visa.
2015.
Okay,
No.
one at a time, gentlemen. All
It
right.
has nothing to do with the reporting because it's the source of dollars that Mr. Elkins put into the account. I'm not saying it's a
Oh,
campaign
okay,
loan, it's a
gotcha.
personal loan for the source of
Right.
dollars.
Okay.
So that was Madam Commissioner, that was the challenge we had of trying to align those. But the purpose was to show that this was not a sense where, dollars were being provided by nefarious sources and Mr. Elkins was in some way using this to launder money or something like that. That there was a source, his personal source for these dollars, and he used it for personal expenses.
Okay. Thank you.
Mr. Sims?
Nothing further unless you would like some comment on disposition at this point.
Yeah, we'll conclude with that. You'd indicated, though, that you might call several Board of Election witnesses,
Um,
and that's your call.
That is all we're going to present from
Okay.
the Cuyahoga County Board, Chairman Price.
Okay, thank you very much. All right, well, then, are there any other witnesses to be called by either side at this point in time? Because what I intend to do is to give each of you an opportunity, counselors, to kind of sum up, and then we'll close the evidentiary phase of this hearing so that the board can get on with the deliberations. So, any other witnesses to be called by either side? All right, if not, then we'll move on. You'll have an opportunity, Mr. Sims, if you'd like to go ahead and sum up, and then Mr. Rupert will give you an opportunity.
I'm just going to be very brief, Mr. Chairman and other commission members. I think we've laid out a scenario of as I said before in my final comments when I first spoke about Mayor Elkins simply engaging in repetitive, excessive behavior over a period of time. The issue around the payment to the LLC, it's a distinction without a difference. I mean, that money went directly to him. It shows up on his federal tax form of his Schedule C. He is the one that filled out the check, campaign check to go directly to the committee, and he is the beneficiary of that money, whether it's to pay for other things for the LLC or to pay him directly. It really does not matter. So, based on what we've presented today, based on the comments we've made and the input from other commissioners asking questions of Mayor Elkins, we will request that the commission impose a maximum a fine. It's, again, as I mentioned, the worst form of the offense, in my opinion. If you put his behavior on a continuum, he is a frequent flyer in front of this commission of repetitive violations starting back to 2005. And we would also encourage this commission to refer the matter for prosecution. Thank you.
Thank you, Mr. Sims. Mr. Rupert?
I'll be brief as well. Thank you for the commission for your time. I know one of my intents was to explain and clarify, and I sometimes wonder if we've achieved that here. But I think the focus here is, again, we have to look at what's being charged and what actually happened. There's two violations alleged: the personal use of campaign funds. Again, I would stress that essentially has been admitted as concerns the commingling by Mr. Elkins here. From the beginning, he identified it himself with his cooperation with the board. So that is certainly something he admits the mistake. I think you see to him the second part of that, the failure to file false statements, that there is no real intent to deceive here. There is certainly a misunderstanding of law. It was certainly sloppy. As I said, it's certainly not best campaign practices, and a questionable whether it was smart to do or not. But there is no there's a lack of intent to deceive here. There is no any evidence been produced that he has in any way tried to limit the board's access to materials when they were requested, that there was a specific reason why he did not report some of this other than his own misunderstanding, and it was corrected. He's admitted to it, and I think he would certainly accept punishment for that and then correct his behavior in the future, much of which he's already done. So with regards to the $8,400, it's a gray area. As a campaign finance lawyer, I deal in gray areas all the time. Some of them make me uncomfortable because clients require you to push far into the gray area to get the maximum benefit for your client. But the reality is that the question is this, as Mr. Richter said, prohibited by law for him to do this? It's gray, it's unclear. Mr. Richter said he couldn't think of anything that says you could not specifically not do this. Is it something we wish the law expressly prohibited? Yes, perhaps. But again, I go back to, and I understand federal law isn't controlling, but it should give us some guidance as to the overall approach we should take to this. And I don't think that's inappropriate for a finding of a violation. Finally, again, I just want to stress the most important of the charges here is that failure to file statements or filing false reports. He participated in the audit and amendment process. He identified the violations to which he's admitted to today. Everything has been provided. There's no outstanding requests for anything. He continues to work with the Board of Elections. So I think it should certainly be considered when thinking with regards to penalty. Is this appropriate for a finding of responsibility and an imposition of a penalty? Absolutely. I don't think anybody here disagrees with that. Is this a case that there should be with the absence of evidence of intent to violate the law and deceive? I certainly think it doesn't amount to the standard we would have for any sort of criminal referral or further action. I appreciate your time. Thank you very much.
Thank you very much, Mr. Rupert. Thank you very much, Mr. Sims. Is there any reason at this point in time that we should not close the evidentiary phase, ladies and gentlemen of the commission, and move into discussion? All right, then I will go ahead and close the evidentiary phase of this hearing, and commission can now begin its discussion of what action, if any, it decides to take. Commissioner Norman?
I guess I'm on the hot seat, huh?
No, I knew you'd have an idea, so.
Well, to me, it defies logic that somebody who's been a politician since 2004 up until 2015 has no idea that he has to keep separate funds that are campaign funds that are personal funds. To me, it shouts at the kid in the candy store who's dipping a hand doing whatever he wants. He admitted at one point in time, he goes, I realize it's a serious infraction. He has admitted to 650 some odd violations of the campaign laws of the state of Ohio. He wants to draw a distinction as to the money going to his account, but he testified that the money went in, but he hadn't earned all those services yet. So to me, that is a misrepresentation as it relates to the payment to the LLC. He described his actions as quote unquote the activity in the account, but he had his own account at home. And if he wanted to pay for his visits to the bar or the grocery store or the liquor store or getting a haircut, he had an account which he could do that and chose not to do it. He wants to use the term, these are my own dollars, but we're going to set precedent here. And let's assume that none of these were his dollars and they were all donors' dollars that are going to the account and he was doing this. I can't think of a situation that would scream more than somebody who needs to have a serious violation brought against them than what we've seen here today.
Thank you, Mr. Norman. Other board members, commission members?
I have a question for Mr. Richter. On the issue of intent, is there, I mean, I understand it's under 3517.13.0, there is I mean, it does say knowingly give, which I think if you write a check, you knowingly give. But is there a scienter or intent provision associated with 3517.13.0?
I'll double check, but just to look at the specific provisions, but beyond what you read there isn't anything else that that you can really read into it. No.
Okay.
You know, the statute is very straightforward. I'm sorry, go ahead.
No, that's, I mean, I'm looking at the statute and I understand the argument of intent, which may relate to whether or not criminal proceedings are brought, but I am just not seeing that as one of the elements that we consider as a board. And usually you have that, I didn't see in your report that you had that set out. Usually you have that set out for us, but when I read it, it just says that you know, no beneficiary, campaign fund, or other person shall convert for personal use.
Right.
You know,
Yeah.
anything of value from the campaign fund. And it says, and no person shall knowingly give a beneficiary of a campaign fund or any other person for the beneficiaries or the person's personal use anything of value from the campaign fund. I'm not seeing this scienter element that's being discussed as part of that statute, and I'm happy to have other points of view on that.
Well, and I know Scott was getting ready to talk about something. You know, one of the other provisions we have before us is the 13G provision too, which specifically starts out, no person shall knowingly conceal or misrepresent contributions given or received. You know, when we dealt with the false statement statutes, as you're well aware, Ms. Cunningham, there was an element of, you know, the knowing element. And certainly as you later on, as you review 13.0, you know, it talks about it, but the very first portion of that statute says, no, you can't do it. And it leaves it at that. And it doesn't say anything else. It doesn't give any other kind of, oops, I made a mistake kind of that.
Well, and I think that you have commented to us, there was one.
Catherine, you may want to stop for just a second. Looked like Phil froze. And then maybe he's back.
Bill?
He's back.
Did I?
Okay. You had frozen
Well,
for
I
a second.
noticed something came up on my screen, but I'm here.
Okay.
Okay. So, and that
I'm
same statute is talking about the campaign fund. And is the campaign fund the bank account? Is that one and the same?
Yeah, as usual, that's where you get into, what's the, what the statutes say specifically as to other elements of it. But essentially, yes, is what I would say, because if you have a campaign account and it is intended to take money in and expend money out, and as the provisions, I think it's 10D say, you shall have a separate account, account separate and distinct from your personal or business account. That's where your account is, so that when you take money in. Now, certainly you have the ability to run a campaign and never open an account if you don't ever take any money in and you don't make any expenditures. But once you open that campaign, once you file that DOT, the designation of treasurer, create your committee and start accepting contributions, wherever those contributions come from, the expectation, I think, under the statute is there is an account out there, separate and distinct from all other accounts, that is the financial account for that campaign committee. Now, can you have other accounts, like if you want to invest money, et cetera? There isn't a restriction on that, but that's separate and distinct from what we're talking about here. Once you file that DOT, create the campaign committee, there's an expectation that you are creating an account into which campaign funds will go and be used for campaign purposes. Now, the 13 O, P, Q, and R provisions allow for certain additional uses related to your public office, et cetera. But when you're talking about campaign funds used for campaign purposes, it's totally separate and distinct from personal use, as is phrased in the very first clause in 13O.
So once deposited, it becomes campaign funds.
That has always been my understanding, yes. And it
And
doesn't matter what.
I'm sorry.
No, you go ahead.
So if it were a loan, then you would have documentation of a loan and pay yourself back. But if you don't have that prior to the contribution, it is part of your campaign funds.
It is a contribution, period, end of sentence. Yes.
Okay.
Certainly we know that there have been, I remember a case, well, not a case, but there was a circumstance, and I relate it here only because there was a campaign account opened, and the only reason, a variety of years over the years, it remained open because there was an outstanding loan that was documented and listed in the campaign finance report. And that's the reason why you kept a campaign account open, so that there's a variety of reasons why you couldn't necessarily just forgive the loan, whatever they may be. But if that's not reflected in there and it's not a loan, it's a contribution. That's the only, there can be other funds, but other funds is generally listed as, interest income, et cetera. It's contributions or a loan that essentially make up a campaign committee account. And if it's not a loan, it's a contribution. Money comes in, it's held. It is then presumably used for campaign purposes, primarily.
Okay.
So I'm going to speak up again because you had all had seen an opinion from Mr. Richter, and it was due to my inquiry about our potential penalties and what we could do. And my question was posed was, if we impose a fine and Mr. Elkins were failing to pay it, can we make that part of our provisions that if he doesn't pay what we impose as a commission, then we can refer this for further prosecution? And I believe Mr. Richter's indication was we can and we are allowed to do that. And I guess in part I looked at it because he had violations in 2006, 8, 9, 10, and they weren't paid until 2011. And there's no indication that there was no service and there was no information available to him, but they remained completely undealt with until finally it reared its ugly head in 2011.
Phil, for discussion purposes, a question I have is a follow-up there. Is it possible to impose a fine and still refer for criminal prosecution? Or do you have a potential double jeopardy issue there, depending upon the size and the amount of the fine?
Right. I think the way the statute reads, we have to choose one of the three options available. So I don't think that you can both refer in the same finding, I don't believe that you can both refer and impose a fine based on my reading of the statute. Now, kind of as I indicated in the memo, you know, we have long, you know, provided the ability to have matters reconsidered by the commission after we impose a fine, at which point we are specifically imposing a fine, but we are giving ourselves the ability to reconsider a matter at some point. Then when we take it up under reconsideration, we have regularly continued with a lesser fine. We have also found good cause not to impose a fine. So we have then made available to ourselves, you know, those three options again, once we reconsider a case. So I think by the inclusion of a reconsideration of the commission's finding, we could take a matter back if it is not dealt with sufficiently for us, and then do one of the other two, well, I shouldn't say two, I should say all three. If we want to reconsider, and as we've done before, you know, we've taken matters, imposed a $100 a day fine, but give the person the opportunity to have the matter reconsidered. They make their payment, they make their campaign finance filings, they come back to the commission, and then we impose a lesser fine amount. So we've done fines. We've reconsidered matters and chosen the option to good cause. The number of times we have actually referred matters for prosecution, period, over the years has been only, I'd say probably 10 or 11 times since it became an independent agency. And so it is not something that we have done on a regular basis. We have reserved, I always say, we reserve that for what we view to be the most egregious cases when we refer matters. And so, as I indicated in that memo to you all, based on Mr. Norman's request, I think if we were to decide that we wanted to impose a specific sanction, but if it wasn't fully complied with, give ourselves the ability to reconsider the matter and do something else, I think there's the ability to do that.
I have a question based upon Mr. Kreit's question to you, which is, let's assume we impose a monetary sanction and Mr. Elkins doesn't pay it, but he's paid, let's say, half. Can we then reconsider and send it for further prosecution now that he's formally complied? Does the commission have to return those funds? How is that handled?
There is not. No, I don't believe so there. Now, I haven't had that question before, and we haven't seen that specific type of situation occur. But I believe we would have the ability. The original finding was not complied with to our requirements, and so therefore I think we'd have the ability to reconsider it and do whatever. Could be payments are made, and the commission maybe becomes satisfied that there is compliance. Reconsider it and declare it done, more or less, or take it back, reconsider it, and take the action that the commission decides they wish to choose to do.
I know we've had discussions leading up to this about whether we should refer this or whether we should impose a monetary sanction. We've not heard from either counsel on behalf of the petitioner or on behalf of the respondent on whatever preferences or indications they may have. I don't know if anybody else in commission would like to hear that.
Commissioner Norman and members of the commission, I have one question.
Who's speaking?
This is Janine Hummer.
Thank you.
Assistant. And this may be for the executive director. If the matter is referred to for prosecution, and if there is a indication that prosecution is not going forward, would your statements regarding reconsideration again be in play?
I'm not sure that I exactly understood, but if we reconsider a matter,
Let me rephrase. If the commission voted to refer the matter for prosecution, and after that referral, either there's a decline in prosecution or there's a no bill, does the commission retain jurisdiction to reconsider and impose a penalty?
We have not done. I don't believe so. We haven't done that previously. When we've referred matters, we essentially prepare the entire record, send it along to the prosecutor, and then the prosecutor decides what they are going to do with it. And I think at that point, I don't know if I want to say similar to a grand jury, but we've been compared that way before in other circumstances. Once we send it along for prosecution, it's the prosecutor's decision as to whether they believe it's viable for prosecution or not. And we're essentially done it over with, if that is the decision the commission makes.
Thank you. I'll defer now to Mr. Sims.
Thank you.
Because I will interject then too. And primarily our decisions for prosecution have been, if they've been financial, once it's gone to the prosecutor, they've been involved in other cases, or resolutions have been worked out and fines paid through the court system. We're not involved. When we were dealing with false statement cases, we had cases where we referred it for prosecution. We received notes back from the prosecutor's office that the matter would not be prosecuted for whatever reason. I don't recall that a reason was given to us for false statement cases. And we've also seen matters for false statement cases go forward and a resolution be reached between the prosecutor's office and the person for substantial fines. But again, that was done in the court system, separate and distinct from what the commission does.
And I suppose Mr. Kreitz would be a better person to address this than myself, because I'm on the civil side. But when you've got the stipulated admissions, we've got to 650 violations with the tune of $134,000. It would seem like it would be a slam dunk for the prosecution to actually prosecute and prove that the campaign finance laws were violated.
I can just tell you, Mr. Norman, having been a prosecutor for 20 years at the state and federal level, there's no such thing as a slam dunk. I'm not being critical, but I just did it for too long. And yeah, I don't know. Would this be referred to the Franklin County prosecutor because of our presence here, or would it be to the Cuyahoga County prosecutor? And the question becomes, is there a federal investigation going on in light of the fact that apparently there's Department of Justice subpoenas that are out? Is the U.S. Attorney in the Northern District of Ohio involved? We don't know. So where would it be referred to?
That would be the way the statute reads is we have certain abilities. Generally, my initial inclination would be this would go back to the Cuyahoga County prosecutor's office. Because all the events occurred in Cuyahoga. The respondent is in Cuyahoga, but under certain circumstances, we have the ability to refer, even though the likely place would be Cuyahoga, if the commission so decides, and I'd probably be in conversation with the respective prosecutors, we have the ability to refer it to the Franklin County prosecutor as well, the way the statute reads. But primarily, I think this would go back to Cuyahoga.
But we could make a request that it be prosecuted by the Franklin County Prosecutor's Office. I mean, in terms of judicial economy and efficiency, it appears that obviously the Franklin County Prosecutor's Office is already engaged in significant research and a commitment of time in the preparation for the case today.
Correct. Don't disagree with any of that. I'm just merely saying what the statutes allow us to do.
Okay, but we have the option. Is that what you're saying?
Correct.
Okay.
And I, if I may interject, our participation in this is our participation, whether it's in Cuyahoga or in Franklin County. So the jurisdiction or venue where the matter is heard may not affect our ability to be the prosecuting entity, since we're already engaged as the entity regarding this matter.
So, Ms. Humbert, are you saying? I think I understand that even if this case would be referred for criminal prosecution in Cuyahoga County, in light of the current arrangement you have with the Cuyahoga County Prosecutor's Office, you would probably, your Franklin County Prosecutor's Office would more than likely handle the prosecution?
I believe that's correct, but Mr. Sims, isn't that correct?
Actually, I believe if there was a referral
Okay.
up to Cuyahoga County to Prosecutor O'Malley's office, they would have to kind of re-up, if you will, for us to continue to be special prosecutor
Right.
on behalf of Mr. O'Malley's office, which I would think that would be the case, given the comments by Chairman Kreitz about the significant investment of time and resources that the Franklin County Prosecutor's Office has already invested in this matter.
All right.
And before
May
we-
I ask a question? Mr. Sims, at the end of your statement, did you not, I apologize if I misunderstood, did you not ask for us to move it to prosecution?
To me.
That was to you, Mr. Sims.
Yes, we've asked for a referral for prosecution by the commissioners. Thank you.
Thank you.
And Mr. Rupert, did you have any type of recommendation or anything you wanted to state before the commission?
Certainly, I would say and argue again that this is, I understand that people want to portray this as 650 violations, but we're talking about that was not charged as 650 violations. It was charged for in 3 cases as violations. Rhetoric does not necessarily match the law here. We're talking about a commingling of account, a 1 violation. And again, and I will say, the knowingly portion does specifically apply to the false, the allegation of a false filing. With regards to whether this is appropriate for criminal defense or not, I haven't done criminal defense work for 10 or 11 years, but there is more flexibility for the commission to send a signal with its fines, et cetera, than making a referral for a misdemeanor 1 in this case. And I can't speak, unfortunately, for the prosecution right now, but I can't imagine this is a case they want to spend time and resources on for at maximum $1,000 fine. And I can't believe this is appropriate for any sort of jail time. This seems, as we talked about judicial resources and economy, it seems like the best people to enforce this, to send the message, to is to retain this within the Ohio Elections Commission. I don't have any opposition whatsoever to the retention of jurisdiction to make sure that there's compliance with any fines, et cetera, any remedial actions, et cetera. But I don't think this is appropriate for criminal prosecution. I will state too, with regards to any idea that this is the subject of other criminal prosecutions, investigations someplace else. I can't make representations. I don't believe that's going to go forward for the limited amount of materials that I've seen. And I can't believe that on that matter, that if that was going forward, the Franklin County Prosecutor's Office would remain silent as to what is going on, because they would be put on notice, and they would also be very careful about creating a record for any future matters. So I just don't think this is appropriate for criminal activity or referral. This is a serious offense that can be handled with a serious fine and the sending of a serious message by the Elections Commission and a clarification of what you're actually deciding.
Okay. Are there any other questions, comments by the commission?
Yes, Mr. Chairman, I can't see anybody at this point, but now here you're
We can see
Wait,
you.
you're
though.
back.
you're starting to populate back now. I agree. I think this issue is before the Election Commission. I think we should be able to resolve it. And certainly the fact that there's already been a stipulation that the funds were commingled and that he was using campaign funds for personal use, I don't believe that's any longer a question, or we even need to debate. He admitted it. And as a result, I think we should be able to come up with a fine commensurate with him admitting that. The other thing I'm still a little unsure of is this $8,400 LLC. I guess, Phil, and this question is for you. Are we saying that a candidate can pay an LLC that for campaign assistance, if that LLC is owned by the candidate, and presumably that the billing is for legitimate campaign expenses? Are we saying that's okay?
Essentially, the statutes don't prevent it. So, I mean, at one level, we would be saying yes, that you can do that. You know, what if the services were performed for fair market value for valuable services, there isn't anything in the statutes that prevent that. I think Ms. Tavares made some excellent points when she was talking about this and what candidates do. It is something that is rarely done, I would guess. At least it is not something that this commission has ever been presented with previously. I think Mr. Rupert commented he certainly wouldn't recommend it. I know my statement is what the statutes specifically prohibit, and they do not. But it is certainly something that I don't know is a very good manner for conducting your campaign from an appearance sake primarily. But you know, it's certainly rife with the possibility of overpaying for certain services and having. You know, and I'm not saying that occurred here, but overpaying for certain services and essentially improperly using campaign funds.
Well, and I have the problem with it because he's paying himself and he goes, this was for the full year, but I hadn't earned those services when I'm paying myself. I mean, it would be different if you were paying an outside service and they say, look, we're going to do this through the campaign and it's a flat fee. But here he's in control of his own campaign. He's in control of his own LLC and he's saying, I'm giving myself the money whether or not I'm going to earn it or not at the time that he pays himself the fee. So to me, it just doesn't pass the smell test.
See, that's why I don't think that the way that we're going, I don't think that and this is to Mr. Bromer's comment, I don't think we're creating a sweeping rule. I think you do look at the nature of the services and the nature of the expenditures or whatever, because there's, you know, and I don't want to get into hypotheticals and I won't. I could come up with a scenario where, you know, expenditures were made out, let's say it was $8,400 and $7,800 were paid out through the LLC to another organization for outsourcing or something, then you would have a better argument, for instance. But I don't think we're creating a sweeping rule. I think it is a facts and circumstances of the nature of the expenditures and the nature of the services here, since we have services involved.
Yeah, and I'll chime in real quick just to say, yeah, I think that's exactly right. Anytime that it is an expenditure like that is made, there could be reasonable questions about it. The questions may end up being answered appropriately for the campaign committee, but it's appropriate to ask the questions and assure that the funds were used properly.
Anything else? Thank you, Otto. Were we at the stage where anyone is prepared to make a motion?
I think what we as a commission probably should do before we make a motion is kind of get a feel for where we are as far as imposition of a fine and or referral for prosecution. And I think the general flavor is, and I think I'm in agreement, which is, and I'm consistent with Mr. Rupert, let's keep it in-house. But I look at it, and the problem I have with it is you've got a career politician, and I'm not saying a career, but at least 11 years before the event started getting investigated. And then you've got 5 calendar years where he is dipping into the account repeatedly and overly to the point that there's an admission of 600 violations. And I think this commission is going to have to take a big bite into this, because I think precedent is going to be set into the future, whether people are going to use this as their own candy jar or not. And I think we as a commission have to say what he did was completely inappropriate, and we need to make sure that the general public and the political population knows that what he did is completely inappropriate.
Mr. Norman, I would agree with everything that you said. And for that reason, I feel very strongly that this is a case that needs to be referred for prosecution. I mean, this has got to be one of the most egregious misuse of campaign funds for personal purposes that we've seen, at least in my tenure here on the commission. I mean, essentially he uses campaign funds as a personal piggy bank. And I think we have to send a message. If there's any doubt out there amongst our political community that this is not permissible, I think we need to send a message out very clearly that it is not permissible. And I personally favor and strongly in favor of referring it for prosecution.
And I'm going to express opinion because originally that's how I thought. But I also thought if he's going to get hit with a misdemeanor and $1,000 fine, as opposed to what we as a commission can impose as far as a fine and a sanction, I think it's going to be far more detrimental to a candidate than what they're going to face as far as political or a criminal prosecution. And I don't know how anybody else, I'd like to hear from everybody else.
Mr. Chairman, this is Commissioner Tavares. I guess in light of Mr. Norman's comments, the most that he could be brought up would be a misdemeanor. Is that accurate?
I don't know, and I don't think somebody suggested it's a misdemeanor, but I mean, no one's really had an opportunity to take a look at the Ohio Revised Code and to see what other possible charges could be raised. So I think we have to be really careful about categorizing this as either a misdemeanor case or a felony case, because none of us know that.
And maybe we
351799G. Whoever violates Division O of Section 3513 of the Revised Code is guilty of a misdemeanor of the first degree.
So is there any question then that the general statutes of Title of the Ohio Revised Code can't be used in addition to Title 35? Title 29, are there offenses under Title 29 that arguably could be brought into place here? I don't know. I haven't looked at it. Yeah, I understand what Title 35 says, but I don't believe that that's exclusive, and I think that the prosecutor would have the opportunity to look at potential Title 29 violations.
So I'm going to step up and say kind of maybe what we did in a previous case, which is we've got 30 days to render our opinion. And I'm inclined to say maybe we can get some of those further elucidation from either Mr. Richter or from the prosecution on what's available.
I think that's a good idea. Because until I know for a fact that it can only be a misdemeanor, I'm very strongly in the camp of referral for prosecution.
Yeah, I mean, I can only really speak to, at least at this point, you know, what the commission's authority is and what we're enforcing. It's the election statutes, and that is what we would be referring is the violation under the election statutes. Now, obviously, based on the presentation here today, what we have presented to us is, you know, essentially 650 violations of the statute, which is available to us in terms of, to me, is available to us in terms of making some sort of a monetary finding. But, you know, I can't speak for what would happen when we send it along to the prosecution saying, here's all the evidence we have. Here is what has been presented to us, what we found. Here's the evidence. It is now up to you to make a case. And I don't have the experience to speak to what other potential Title 29 violations may be out there. But then you get back to some of the questions that Ms. Cunningham was asking about the Siena aspect of, you know, how that fits into all of this and how that may come into play. And I don't have the expertise to deal with that.
I know we have as a part of our conversation today with Mr. Sims and Ms. Hummer, who are part of the prosecution team. I don't know if they're able to shed the light or if they need more time to be able to shed light on that, but that might be helpful for all of us considering today.
Folks, let me speak on that issue, if I may, to the commission. I would hesitate to preview what charges, if any, could be brought against Mayor Elkins for his conduct in this situation. But let me do say that Mr. Chairman Kreitz is correct. 2929 is fully in play here, and that that doesn't involve misdemeanors. It involves felony offenses. So I don't want to say much on this issue because I do not want to be accused of trying to sway the commission one way or another. And in my opinion, the commission either has to make a decision to refer for prosecution or not. And if you refer, then it's out of the commission's hands, as Mr. Richter has pointed out, and then it then becomes our purview to decide what, if any, charges would be filed either in municipal court for misdemeanor offenses or in common pleas court if we did so, in fact, present cases in front of a grand jury, whether it be the Cuyahoga County grand jury or the Franklin County grand jury for felony offenses. Not to say that either of those grand juries could not also consider misdemeanor offenses as well. Thank you.
Mr. Sims,
And
I'm
if
gonna,
I may, if I may add to Mr. Sims' comments, I think it's also important to note that even if those offenses are misdemeanors, it's not just a single misdemeanor charge, and you have the ability by law to impose up to a year and a half. That's a maximum penalty, no matter how many charges you have with regard to available jail time for a misdemeanor of the first degree, and each one of those would carry $1,000 fine. So I think thinking about it in terms of the cumulative effect is also important as you go down this road.
thank you, Ms. Hummer. Mr. Sims, I'm going to steal a quote from former Judge Hogan. I'm just a dumb old civil lawyer.
I know Dan very well.
When you start talking about Title 29 and you're referencing the potential for felony penalties, what does that mean to the rest of us who don't dabble in the criminal world?
As Chairman Kreitz pointed out, Title 29 is our Ohio Revised Code criminal section that lays out criminal offenses from aggravated murder to low-level felonies of the 5th degree. So that is what I am referring to.
Thank you.
I think, Mr. Chairman, once again, I guess I'll restate my position on this. I think this issue is squarely before the Ohio Election Commission, like other issues that we have dealt with over the periods. And I just think that instead of dealing with hypotheticals, what might happen in court, it's before us now. We know what occurred. We know the facts. I think it's our job, and it's incumbent on us to issue a penalty commensurate with the violation. We know the scope of the violation. We certainly have the right to assign a penalty commensurate with that. And I think we should.
Okay, thank you, Mr. Bromer. Anybody else?
I'm going to chime in and say I completely agree with Dennis. I think that it's incumbent upon us to take everything that we've heard and make the right decision and set the precedents for those cases going forward.
Thank you.
Phil, can you remind us what the penalties are for that would be, please?
Easy for me to say. For personal use, it's a fine amount of up to $1,000 per instance. Let me look at the other provisions. For late filings, filing incomplete reports, it's up to $100 per day for the amount of time that the reports were outstanding. And if we've kind of not really talked about concealment or misrepresentation here, I don't know that was really established. But that would again be a fine of between $100 up to $1,000 if we did that. Those, I believe, are the fine amounts that we have available to us. I don't know that we've really specifically had anything specifically laid out to us as it relates to filing later incomplete campaign finance reports as it relates to the daily fine amount. But I think one we'd be looking at is $1,000 per instance kind of based on the misdemeanor penalty sanction that Mr. Rupert referenced. It's available to us, but administratively up to $1,000 per instance.
So as it relates just to the violations, that would then equate to 650,000, correct?
That's the maximum, yes.
Okay.
Any other questions? Are we prepared to act today, ladies and gentlemen of the commission? There's been some suggested that maybe a 30-day delay, but what's the sense of the commission?
Well, I've
Mr.
heard
Chairman, I would prefer the 30-day delay so that we could take the time to look at all of the penalties and determine whether or not we believe that maintaining commission authority or moving it, referring it to criminal prosecution is what we should do, one way or the other.
Thank you, ma'am. Any other thoughts?
Catherine, Otto?
I support delay if any commissioner wants it.
Okay.
I'm sorry, I may have gotten a little confused here on the issue. Is the delay to consider the referral or no referral, or is the delay to have more time to re-examine the conduct and determine what the appropriate penalty under our jurisdiction would be if we chose to retain it?
I'm hoping it's both.
Both.
Okay.
Mm-hmm.
Phil, is that accurate?
Well, I would say it's, we've seen the activities presented, et cetera. We have the evidence. It's a matter of taking that 30 days to figure, and presumably there would be the violation of a finding or the finding of a violation. Let's try it that way. But it would be a matter of us outlining what penalty we choose in the intervening period, laying out what penalty it is that we choose to impose based on the evidence that's been presented.
I mean, I personally, after reading all the papers beforehand and then hearing both the arguments as well as Mr. Elkins' testimony, I need some time to process and put all that together. And that's why I was talking to the delay on the substance of it.
And I'm going to again reiterate to the commission that my inquiry to Phil tied back into that very same thing, which was if we impose a fine and we give Mr. Elkins whatever time we might hear that would be necessary to pay that fine, and if he does not, whether we could refer that for further prosecution if he doesn't comply. And I think all the commissioners should maybe keep that in the back of their mind as we're getting more information from Phil as to what we can and can't do as we proceed the next time this is pulled before us.
Excellent. All right, do we have a motion then to delay the decision for 30 days? Excuse me.
Norman, so moved.
All right.
Tavares, so second.
So we have a motion and a second to defer the final decision on this until is it the April 8th meeting, or do we want to use a full 30 days, Phil?
I'll leave that to you guys.
Full 30 days, folks?
If I may, before you take the vote, are we saying we're delaying whether to find guilt or innocence and then a penalty or prosecution? Or are we saying we're just delaying to determine the penalty? What are we saying here?
The whole decision, I think.
I think so too.
We've not made a vote. We're just now delaying it for 30 days so we can get further information from Mr. Richter so that we can be fully educated either on the 8th or the 22nd. I'm guessing the 22nd works better for Mr. Richter as it gives him more time.
Right. Well, and let me interject quickly. What we're talking about here is the provision allowed to the commission under 3517-155C, which 3517-155 lays out that if the commission makes a finding of a violation, it does one of three things: good cause, fine, refer to appropriate prosecutor. Item C under that says the commission shall take one of the actions required under Division A of this section not later than 30 days after the close of all evidence presented. So the close of evidence was today. We now have a 30-day window based on that provision to take one of the actions required of us under Division A of this section.
And we have a meeting on April the 22nd, correct?
We have a meeting on April 22nd, correct?
Can I make a suggestion while we're all here online?
Of course, go
Maybe
ahead.
each and every one of us check our calendars, whether the 8th or 22nd, we have any conflicts so that we're all available?
Mr. Chairman, I have a conflict on the 22nd.
You do? Okay.
I can do
You do it the 8th?
I can do the 8th. Yeah.
Does
I mean, I'll
anybody
make
have a
sure I get
conflict?
done by the 8th. You
Anybody
guys
have
are asking
conflicts
me
on
to
the
do
8th?
you guys are asking me to do a heck of a lot of work, though. I mean, come on.
This is Commissioner Norman. I'm available on the 8th, and that's why I asked the question.
Any questions or any
Yeah.
any problem with the 8th? Looks like we have everybody.
I'll make it.
All right.
I'll be here.
Dennis?
Yeah, it looks good on the 8th.
Okay.
There we go.
Let's do the 8th.
All right.
So we have a motion that's been duly seconded to go ahead and continue this until the 8th of April for the discussion. All in favor of the motion signify by saying aye or raising your right hand. Aye.
Aye.
Opposed, same sign. The motion carries.
Thank you very much.
Okay. All right. In connection with the Elkins case, ladies and gentlemen, thank you, everyone who was there, who was present, who participated. As you heard, we'll be rendering a final decision on this on April the 8th. So, go ahead and tickle that up on your calendar so that you can be here for that if you want to. Phil, is there anything else to come before the Ohio Elections Commission?
No, there is not, Mr. Chair. I think we have covered all the business for the day, and you have given me my marching orders.
Okay, is there any other business to come before the commission then?
Anybody else have anything else?
Well, all right, I'll entertain a motion to adjourn.
So moved.
Norman, second.
Well, we have a motion that's been duly seconded to adjourn. All in favor signify by saying aye or raising your right hand.
Aye.
Aye.
Nice job, all. Very
Thanks,
good.
everybody.
Thanks,
Appreciate
everyone.
it.
Thank you.
Marathon session.
They
Hey,
say
yeah,
that,
Phil.
Andy.
Take care.
Yeah. Yeah, I'm
Phil,
still
I have
here.
to tell you, on that little screen there, you look like Mike DeWine's brother.
I didn't know that Mike DeWine had a
Hey,
brother.
doesn't he?
I don't think I've ever had that one thrown out at me before. I've had various comparisons, but not that one.
I'm not sure that was a compliment.
I know it was. I kept looking here and I think, when did Mike DeWine sneak in there?
Phil, Mike DeWine would be honored to be your brother, I'm sure.
Oh,
how nice.
I appreciate all of those comments. I'm not going
I
to
don't
make
know
any
about the
other.
other spin, but
I am not
Maybe
making
it's the
any other
Florida
additional
effect.
comments.
We're still a matter of record.
Mhm.
No, we're adjourned. We are being taped. Correct.
Yes.
Thank you very much, guys. Take care.
Yeah.
All right.
See you the 8th.
Thanks.
enjoy your
Bye.
vacation, Phil.
I will do my best, my day, and then I get a long drive back. All part of the fun.
See you guys.
Hey, everybody.
See ya. Thanks, Natasha. Can't complain about that comparison, I guess, can I?
Yeah. I figure we'll give this a little bit to kind of digest before I download the video onto the computer, because I know it's kind of laggy.
Yeah, Scott's
so-
calling me. This ought to be good. I'm tired of being around you. What the heck are you want now?